Good day and welcome to the Terminating the Relationship chapter, which is Chapter 4 by Charles Fleischer. When a decision has been made to terminate the employee, the decision should be well documented and tied to the employer's business needs. Some examples may be poor performance or repeated incidents of misconduct. There is a list of questions that an organization can use to help make the decision of termination. Those questions are found on page 65. Our text covers termination procedures. It is recommended to schedule a face-to-face meeting with the employee. It should be a private meeting behind closed doors. There are other procedures in the text, and this section will be part of your discussion post this week. Also in our text is a list of things that should be taken care of immediately after a termination meeting. Please read over that section as well. Once an employee is terminated, it is imperative that they receive any pay owed to them. As far as accrued leave, such as sick leave or vacation time, that would depend on the company's policy. But in most cases, the terminated employee is not entitled to accrued leave. Most companies expect a 2-week notice for employees who resign. But if the employee fails to provide that notice, the company cannot force the employee to work the 2 weeks. On the other hand, if an employee gives a 2-week notice, but the organization does not want that employee to continue to work, they can continue to pay the employee for the 2 weeks while relieving them from all of their duties. This is called garden leave. If an employer offers an employment contract for a specified time, the employer is bound by that contract. In fact, the at-will status is no longer at play. There are, however, some good cause reasons that employers can let the contracted employee go. For example, the employment relationship implies duties such as showing up to work, having reasonable skills, and a duty to refrain from threatening behavior. A breach of such can be a cause for termination. Some employment contracts provide severance pay, even if the employee is terminated. However, unless severance pay is in the contract, employers, for the most part, are not required to pay. Read over the section entitled Severance Payments and Releases for additional information. Our author gives a great definition for the term constructive discharge. He says, it appears that the employee quits, but because of an underlying circumstance, the law concludes that they were fired. The working conditions have become so intolerable that a reasonable person would quit. Please read over the sections entitled Retaliation, Whistleblower Regulations, and Abusive Discharge, all terms we have looked at this semester. Defamation is when someone makes a false statement that injures a person's reputation. There are 2 types of defamation: a written defamatory statement is called libelous. A spoken defamation statement is called slander. When looking at giving a job reference, can one be accused of defamation if the reference goes beyond the questions asked? Well, some organizations have adopted a neutral or no comment policy. In that situation, the former employer's reference includes dates of employment, their job title, and possibly salary. When looking at due process for employees, remember that at-will employees can be disciplined or fired at any time. However, there are some exceptions. Our chapter concludes with downsizing and layoffs. The best way to avoid layoffs is to consider other ways to cut costs before letting employees go. This concludes the review of the Terminating the Relationship chapter. Have a wonderful day.